Xin kính chào các anh chị. Lời đầu tiên, thay mặt chương trình Thạc sĩ Quản trị Kinh doanh Andrews, tôi xin hân hạnh được chào đón tất cả các anh chị đã tham gia buổi tọa đàm trực tuyến của Đại học Andrews Hoa Kỳ ngày hôm nay.
Xin cảm ơn chị Thảo Ngân. Thưa anh chị, để cho tôi xin đầu tiên là tôi cảm ơn các anh chị học viên cũng như cựu học viên của chương trình MBA Đại học Andrews đã cùng các khách mời đã tham gia cái buổi tọa đàm ngày hôm nay. Tôi cũng muốn nhấn mạnh các anh chị rằng là hy vọng cảm hứng từ cái buổi thảo luận hôm nay sẽ cho anh chị hiểu tại sao người ta nói rằng là luật kinh doanh là một công cụ, một the most powerful weapon for both defense and attack in business strategy. Tức là một cái công cụ mạnh mẽ nhất trong cả bảo vệ lẫn tấn công trong chiến lược kinh doanh. And now it's really our pleasure to have Mr. Vasoli, one of my best friend, and he would like to present the presentation on the international contracts. And Mr. Vasoli, it's our pleasure, please.
Thank you very much, Dr. Viet-Anh. And thank you everybody for joining this webinar. I would like to extend my thanks to Andrews University and to the National Economic University of Hanoi. As I said in the presentation, I'm originally from Italy, but I am a cross-jurisdiction lawyer in that I work in different countries. I have my office in view from Hanoi, in Ho Chi Minh City, Singapore, and Malta. For those of you from Vietnam that do not know Malta, it is a small jurisdiction, a small island south of Italy. I have been practicing law for many years, and I have always been working with on international business cases. What does that mean? It means assisting companies setting up their subsidiaries abroad, merging, selling, buying, and so on and so forth. So all that means getting to know different jurisdictions and learning not just about the technicalities of the law, but also the beauties of the cultures and of the people behind that. So without further ado, allow me to share my screen because I would like to share some slides with you. Let me see if that can be done. No, I cannot. Anyway, the main points that I'm going to touch on today for you all are the definitions of a contract and of an international contract. What is the applicable law and what is the applicable jurisdiction? And a few examples of contract formation and typical mistakes and typical solutions. Usually when I give these presentations, when I give these lectures in presence, in Italy or elsewhere, I usually ask people to answer a question to raise their hand. Of course, it is not possible to do that here due to COVID-19. But the question that I ask is if you have entered a contract recently. And whether you know it or not, I don't know how many of you are versed in law. Perhaps there are lawyers that have joined, perhaps there are people who studied law. But the answer is yes. Contracts are the basic form of civil law. So everybody enters into contracts on a daily basis. I'm having a coffee here at home, but if I had bought the coffee at a bar, or if I had breakfast outside, had I had my phobo outside, that would have been a contract without realizing that. So many people think that a contract is that boring, long piece of paper or document that you see on your computer. But the reality is contracts can be formed in many different ways, including verbally. So unless the law requires otherwise, a contract can be formed at any time. A contract is an agreement between two parties or more parties that have legal validity and can be enforced. So there are various definitions for that. So what is a contract? A contract is yet a simple and a complex issue that should be regarded as an instrument in the hands of the parties. Some people find contracts boring. Sometimes they are boring, but they're actually very useful, especially in the future when the parties do not know how to treat a situation. What is the purpose of a contract? The purpose of a contract is to regulate a business relationship. We're talking about business here. You are following an MBA course, so we're talking about business. It is an instrument that serves to regulate a business relationship and to set up some firm landmarks. So in a world which is characterized by volatility, uncertainty, complexity, and a contract serves to give you some direction. You agree that you do this and this and that. Normally, you don't have to read a contract all the time. Usually parties negotiate the formation of a contract, then they forget about it, and the contract reappears magically from the server, from the emails, from a drawer, the moment the parties are in disagreement. This is why it is important, in practical terms, to imagine beforehand what could happen in the business relationship between the parties. So this is a very broad definition. But what about an international contract? What is the definition of an international contract? What are we talking about today? Well, as I said, the contract is law between the parties. It's the rules, the landmarks that they set. But what is the definition of an international contract? There is none. What is the definition of international law? Well, scholars disagree, but actually it is difficult to define international law as well, in that at the end of the day, it boils down to the rules and regulations set forth by a single state. Very simple example. You have a Vietnamese party, you have an American party. What law do you apply? Vietnamese law or American law? Yes, there could be some international conventions. There could be some international treaties that between Vietnam and the United States or between many other countries that set the common rules to play. But these common rules are then ratified in the bodies of laws of each single country. I come from the European Union. I come from Italy. Maybe you've heard that in August 2020, finally, the EU-Vietnam Free Trade Agreement was and came into force. It is an agreement that binds both Vietnam and all the member states of the European Union. Yet, the ratification of this agreement means that the rules are applicable within those jurisdictions. So if you are from Italy, like me, if you're from Vietnam, like many of you, the content of the EU-Vietnam Free Trade Agreement is, in a way, law of each individual country. So this is very important. There is no supranational body that regulates the relationship between states. Yes, there are international organizations like the UN that do that, but reality is that they are conferred powers by individual states. So having said that, there is no superpower that regulates states, and that it boils down to what each state sets as the law. An international contract can be defined as a contract where the parties belong to different jurisdictions. Mind you, I'm talking about jurisdictions and not states, because there are countries like the US, where some of you probably are connecting from, that have different jurisdictions within the same state. I'm referring to a state, but in the case of the United States, I should refer to the Federation. So the laws of Michigan are somehow different from the laws of the state of New York, or the state of California, or the state of Nebraska, and so on and so forth. So theoretically, very theoretically, a contract between somebody in Michigan and somebody in Texas could be regarded or could be treated with the same principles as an international contract between somebody from Vietnam and somebody from Italy. There are even more peculiar examples. China is one of those. You have seen what has happened in Hong Kong recently. As you know, with the handover from the UK to China of Hong Kong and from Portugal to China of Macau, China has implemented a so-called one country, two systems policy. What does that mean in terms of international contracts? It means that the People's Republic of China has its own laws, and Hong Kong and Macau, respectively, have their own. That Hong Kong is a common law jurisdiction whose principles are totally different from the principles of civil law and those of the People's Republic of China. So they're truly two different jurisdictions, even though power lies in Beijing that has ultimate supervision and jurisdiction over the special administrative region of Hong Kong. The same could be said about the UK to a milder extent. Scotland has relatively different laws than England and Wales. So what I'm trying to say here is that you can have a state whose laws are coherent throughout the territory, like Vietnam, in a way also Italy, but then you also have countries with strong differences between the various jurisdictions within their own territory. So again, back to the definition of what an international contract is that the parties to the contract belong to different jurisdictions, not necessarily states. That is one definition of international contracts. Another definition could be that the parties belong to the same jurisdiction, but the contract has effects elsewhere. So two parties from Vietnam decide to do business in Thailand. That could also be regarded as an international contract. Essentially, the message that I'm trying to convey to you is that there is no key definition, and that we are trying to put together different systems that have the pretense to have supremacy one over the other. And why is this important? It is important because the moment there is a fight between the parties, you need to decide what law applies. This is the key point of international contracts. What rules you apply to the contract itself? And can the rules that you, with the other parties, have put in the contracts be enforced? So, okay, so this is a basic definition of an international contract. But what is a contract? We said it before. Now, first of all, I mentioned briefly the distinction between civil law and common law. It's a fascinating history that divided these two systems in Europe. I will not go into the details, even though it would be fascinating to step back and talk about history a little bit. But essentially, worldwide, we have these two traditional law, essentially the former colonies of the British Empire. Singapore, Hong Kong, to an extent the US, to an extent India, Australia, New Zealand, etc., whose legal system is quite similar. So for instance, setting up a company in Singapore and setting up a company in Hong Kong is quite similar. The legal principles that apply to the law and also to the laws of contracts again, in Singapore and New Zealand and Canada tend to be quite similar. So the devil is always in the details. What I'm trying to say is that these systems tend to be quite harmonious. And as you may have heard before, common law is judge-made law. So of course, there are written laws that are passed by local assemblies, parliaments, etc. But legal precedents are binding in shaping what is law and what is not. In continental Europe, 2-3 centuries ago, there was a tendency towards codifying, putting together the legal systems. Sorry, Dr. Viet Anh has written to me, I think. Okay, thank you very much. Let me share my screen. Sorry for this interruption. Share. Okay, you should be able to see this. Okay, so in Europe, 200-300 years ago, there was a movement towards the codification of laws, which did not happen in the UK back in the days. That is, you had common rules, common law, that were codified in essentially books, in collections of laws. in codes. So in these countries, such as Germany, France, Italy, and many others, and then the other countries that these jurisdictions influenced, such as Vietnam through France, such as China, the law is called a civil law system, where the law is written and then interpreted by judges. The key difference is that in practical terms, a contract in a country like Italy or Vietnam tend to be more synthetic because it refers to written laws. A contract, if you read a contract from Germany, from France, from Vietnam, etc., the contract will likely be shorter than a contract that is prepared by a lawyer from the United States of America, from the UK, etc. Because in these common law jurisdictions, lawyers and parties tend to be more specific and give broader details about what could happen. So they try and think ahead about all the possible scenarios that could happen. So the Italian Civil Code, as well as the Vietnamese Civil Code, define a contract as an agreement between two or more parties to set, regulate, or terminate a business relationship. So the stress is on the business relationship, on the fact that there has to be an economic interest behind it. That is the reason why, for instance, marriage in civil law is not a contract. It is in Islamic law. In Islamic law, a marriage is a contract. In civil law, it is not. English law and common law jurisdictions tend to be a bit more generic. So a contract is an agreement which will be enforced by the law. Very important, as I said before about the example of the cup of coffee that you might have had this morning if you went to a bar, a contract can be entered into with no particular formalities. So be careful. There are many businesses that exchange emails, that exchange messages, WhatsApp, voice messages, Viber, Zalo, whatever. All these pieces of evidence, all these instruments of communication may lead to the formation of a contract. So the practical takeout that I give you is be very careful about what you write in a text, about the voice message that you leave, and so on and so forth. Because unless the law requires otherwise, and Vietnamese law tends to be very formal, so you're lucky in this way, a contract can be formed without any particular formality. So for instance, if you buy a house or if you buy a car, usually you need to follow certain formalities. The contract should be in writing. Maybe you have to go to a notary. There have to be stamps and so on. But if you buy a cup of coffee, no need for particular formalities. The same applies, though, to contracts whose value is immense. So watch out for what you say, for what you promise, and for what you agree. Okay. Now, okay. So we said that there is no such definition as there is no such thing as international law. This is a broad, this is a bold statement, of course. But if there's no super law, supranational law that regulates international contracts, what are the sources? What are the rules that are applicable to a contract between, to a private contract between two parties? Mind you, I have forgotten to say something really important. When we're talking about international contracts, we're talking about international contracts between private subjects. We're not talking about agreements between states, between regions. Those are treaties that have to be that are regulated differently. In that case, international law does apply. Anyway, so what are the sources? The parties can decide whatever, but what do they decide? Is it legal? Is it enforceable? So the first thing to check is, let's assume I'm from Italy, you're from Vietnam, I buy something from you. And we decide that the applicable law is Vietnamese law. Is it okay? Maybe yes, maybe no. We have to go into the details. But if the parties have not chosen the applicable law to the contract. What law applies? Well, sources that apply. The conclusion is essentially the law that is applied to an international contract is that of the jurisdiction that has the closest connection with the agreement. So if the agreement is about shipping something from one country to the other country, let me give you a simple example. If the agreement is about building something in a territory, if you build a house, then 99% of the cases, the applicable law will be that of the jurisdiction that regulates the land on which the building is constructed. If you ship something from country A to country B, then the most peculiar feature of this agreement is the shipping, is the transportation, is the fact that the goods go from one place to the other place. So most likely, they go from country A to country B, it will be country B's laws that apply, because the key obligation is that to transfer the goods from one country to the other. But there are, of course, exceptions. For instance, think about labor law, think about antitrust regulations, think about, I mentioned it earlier, think about real estate. They all have exceptions. Now, if both parties are members of the EU, this is the second bullet point that you can find here, European law applies. European law is perhaps a wrong definition because the European Union issues directives, regulations, and decisions, not laws, technically speaking. But to keep it simple, let's call it European law. So if both parties are members of the European Union, for instance, Malta and Germany, for instance, France and Bulgaria, then on top of the local laws that are applicable according to the theory and practice of international contracts, you also have European law, which is a good piece of news because European law tends to harmonize regulations across the European Union. For instance, commercial agency is a famous success of the European Union in that it harmonized the regulations applicable to commercial agents all across the EU, which is not the case, for instance, in ASEAN. In ASEAN, still, there is not so much harmonization of regulations as there is in the European Union. Then there are some private collections, the Lex Mercatoria, international business practices, for instance, in the fields of transportation. This is quite a typical example. There are uniform conventions that have been issued, especially by international bodies like the United Nations. There are models, and so on and so forth. All these points are attempts, not laws, by private or public bodies to try and harmonize regulations. I mentioned, for instance, the CISG, point number 6, which is the Vienna Convention on the International Sale of Goods. That is a fantastic achievement by the United Nations in trying to model a standard contract about the sale, CISG, of goods. So we're not talking about immovable property, we're not talking about financial instruments, we're not talking about digital tokens, we're talking about physical goods. So this convention sets the rules for the sale of international sale of goods, as well as the remedies. This is great, because the convention aims at solving the problems that could arise in the sale of goods, typically defectiveness. Defectiveness is the ultimate problem that you have in the sale of goods. You have essentially two problems in international sales. One is that the buyer doesn't pay, and the other is that the seller doesn't perform its obligations to sell defect-free products. Then there are some collections and models, for instance, Incoterms. You may have seen Incoterms in various contracts. Incoterms are a collection of codes composed typically of 3 letters that set the rules and the liabilities and responsibilities of the parties when goods travel from one place to the other place. So you may have seen the term X works, the term FOB, free of board, and so on. Essentially, when a good is sold from country A to country B, who is responsible in the meantime? You have all seen what happened in Suez with the big ship that is now blocking the canal. What happened to the goods that are in those containers? Maybe you are expecting some goods and you don't know that they're traveling on the ship. You bought those goods. Who is responsible? Are you now the owner of those goods, or will you be the owner of the goods once they arrive at destination in America or in Vietnam? Is the seller still the owner of those goods? What about the freight forwarding company? Who's responsible? Who's taking the risk over those goods? Incoterms define that. So Incoterms are not laws, but they are simplification of these things that I have just said. So liabilities, risk, and so on. So who pays for insurance, who pays for damages, and so on. So how do you form a contract? As I said, it's very easy to form a contract. You exchange a message with your mobile phone. You go to the bar and say, one bowl of pho, 1 cup of coffee, please, and you're done. That is true, but essentially you start with an economic, business, and technological even context. So what is the political scenario? Consider COVID-19, for example, the impact that it's had on global trade. Investments have dropped, but trade has increased, of course. It's quite self-explanatory. So you have countries like Vietnam that have performed really well despite the pandemic, or quite well despite the pandemic, that have encouraged international investors, international companies to sell and buy goods from Vietnamese counterparties. There are legal restrictions in doing business. There are political scenarios, look at what is happening in Myanmar and so on. There are limitations due to the pandemic, for instance, due to culture, due to climate, due to religion, and so on, that create a context. In this context, a contract is formed. So the context is there, and parties are free to negotiate the terms of their agreement. Are they really free to negotiate the terms of their agreement? Yes, but they cannot go against compulsory provisions. For instance, certain clauses are null. I mentioned before, consumers regulations, antitrust regulations, labor law, etc. They cannot be modified at will by the parties. If the parties decide to do something that goes against the law, that provision is not valid. Usually in more sophisticated environments, a contract is the result of other agreements, of other contracts. For instance, confidentiality agreements, NDAs, non-circumvention agreements. These are very important when you do business internationally. What if you go to an exhibition? What if you're online and you're sharing information with so many people? Can this information be shared after the webinar? Is there consent? Is there a binding provision that prevents you from sharing this information? This is quite important because it could result, the sharing, the disclosure of information could result in the impossibility of registering patents, trademarks, and so on. So these preliminary agreements can be vital, can be vital in protecting business interests, and can be pivotal in the formation of a final contract. Then you can have a letter of patronage, as they say in French. What are letters of patronage? They're not contracts, they're not full guarantees, but they are letters that are issued by large groups to confirm that a smaller entity is capable of doing business. Think about the world of startups, the world of tech. Even though startups are now questioned somehow. I was reading an interesting article, I think on the Harvard Business Review recently, about the model of startups. But anyway, you have all these small companies that only have a few years of age or even months, and some of them are very successful and yet very small. Maybe they belong to very large groups like Alphabet, like Microsoft, and so on, but you don't know who's behind them. So if you start doing business with these small companies, you may want to receive a sort of guarantee from the owners that the company is a serious one. Yes, this is a small startup, but Google is behind it. Okay, then we're fine. We trust them. At least we know that technically they're good at doing what they do. Then you have documents like letters of intent, memoranda of understanding, and so on. They can be called in a plethora of different ways. They're not contracts, they're not binding. A letter of intent is not a contract. A contract is a contract, a letter of intent is a letter of intent. Several jurisdictions do not even define what letters of intent and memoranda of understanding are. They usually serve the purpose of setting the final points of negotiations, especially in very complicated negotiations and agreements. We are discussing, this is quite typical in Asia. I've seen a lot of letters of intent in Vietnam and other Asian countries. You are negotiating toughly to finalize an agreement. You are yet to define certain parts of this agreement, but let's assume that you have agreed on price. So price is not a problem anymore. Let's move forward. Okay, we may want to put in a letter of intent that the parties want to do this and this and this and this, and that the price will be X. So the next negotiation will be on, I don't know, delivery terms, but not on price anymore. Price has been set. Is it binding, really? Not so much, but certain parts of the letters of intent can be binding. For instance, standstill clauses. What is a standstill clause? A standstill clause is the provision that prevents the parties from negotiating the same object of the letter of intent with other parties. I want to negotiating with you. I cannot negotiate the sale of this bottle of water with somebody else for 6 months, for 3 months, whatever. So certain parts of these letters of intent can be binding, or for instance, applicable law jurisdiction or confidentiality clauses that are contained in the letters of intent. Many jurisdictions love letters of intent. Many business people love letters of intent. I don't. I think that they can be quite risky and they can be mistaken for at a later stage. As I said, contract formation can be achieved without particular formalities. If you end up in court and there is a letter of intent which is poorly drafted, the judge, who doesn't know anything about the case until it is brought to his or her attention, may interpret the letter of intent in a way that you don't like. So my advice is, if you can, avoid letters of intent. If you want a contract, have a contract. A letter of intent is something different. Sometimes I have clients that come to me and say, can you please draft, can you prepare, can you go through this letter of intent? I say, this is not a letter of intent, this is a contract. I say, no, I'd rather have a letter of intent, a memorandum of understanding, something like that. They are using a different name for something which is not what they think it is. If I call this mobile phone, this is not a mobile phone, this is a bottle of water. I can still call it mobile phone, but it is not. It is a bottle of water. So mind you, if you are in the, sometimes these things can be tricky. Letters of intent may actually be full contracts, full agreements. So be careful again. Names can be deceiving. Then again, back to contract formation, sometimes you have general terms and conditions, which again, I'm not a big fan of. Why? Because they are one-sided. Also, if you look at point number 7, general terms, one-sided terms can be useful in recurring contracts. For instance, in the fashion industry, you may want, better example, sorry. In the logistics business, you may want to change the object of the agreement. So you're storing bottles of water, you're storing coffee cups, etc. But the general terms can be the same. Okay, it is useful to have general terms that apply to both water and coffee, but it is an exception. General terms are not always applicable because they have been drafted by one party only. They can collide against the other party's general terms and conditions. So what I say, practical example. I have a big client from Malta in the cosmetics industry. They work with very large names in the industry. I can give you the names. It could be Christian Dior, it could be LVMH, it could be Unilever, it could be Estée Lauder, it could be these big names. These big names always want to apply their own general terms of purchase. These general terms are totally one-sided, and they totally disregard the interests of my client, who's smaller than these. Even though it's a large company, it is smaller than these huge conglomerates. Solution: instead of fighting over the general terms that have been drafted by big law firms that have been paid a lot of money for these terms maybe 10 years ago, let's draft our own general terms of sale. They have their own general terms of purchase. We draft our own general terms of sale that somehow match and go against the individual provisions of their general terms. So what happens in case there is a disagreement? We fight. There is a collision. Are they applicable at all? And what about the actual contract that we're negotiating? Usually, these general terms have been prepared once and for all. They have to go, and then we forget about them. And once we negotiate the agreements, perhaps the agreement says something different than the general terms. What applies? The agreement or the general terms? Usually, I'll give you the answer, usually what applies is the agreement, because it is the will of the parties. If you remember the definition that I gave you before, it's an agreement that can go. There is this element of will between the parties, the agreement that prevails. However, it could be tricky. So again, do you really need general terms? Think about general terms and conditions as part of the final contract. We visually see two different things. On one side, the general terms that are perhaps on the website of the company, and on the other hand, the actual agreement that we have, I don't know, in Word format, and that we're working on and exchanging the email. Think about it as a single document that puts together the two. If you visualize it as a single piece of document, then you will have a proper agreement. Again, not a big fan. Okay. Formalities and substance. So we have come to the conclusion of an agreement. There is an agreement has been formed. But what about the content? What about formalities versus substance? Let's start from, I just gave you a few examples here. They're not in particular order. For instance, payment terms. As you know, Vietnam has a currency, the Vietnam dong, which is extremely difficult, if not impossible, to exchange outside of the territory of Vietnam. Yes, there are some banks in other Asian countries like Singapore that are allowed to exchange legally to exchange Vietnam dong into something else or something else into Vietnam dong, but generally speaking, it is quite difficult to do so. And as you know, Vietnamese banks tend to be quite reluctant in performing international payments, that is to send currency from Vietnam to other countries. This is a substantial aspect. That is, if we say formally in the agreement that payments should be done, that payments should be made immediately, there is no fault if the payer who is in Vietnam takes longer than expected, because we know that banks here can be quite slow in performing these payments sometimes. The same applies to other countries. I mentioned Iran and Thailand, for instance. Iran is particularly interesting when it comes to the US, since now we're giving this lecture to an American university like Andrews, because there are sanctions involved. So there are very famous examples like that of Standard Chartered, a big bank from the UK, that have been sanctioned by America because they were performing payments in US dollars with Iran without proper justification, and that went against the sanctions that are in place. So again, parties are free to negotiate their terms and conditions, but then they clash against some other norms that they have not taken into account. Then the registration of contracts is a formal aspect. This is an example that I give to my Italian friends and clients. They love to distribute wine from Italy or other parts of Europe here in Vietnam, and then they forget to register the contract. What happens if the Ministry of Agriculture or the Ministry of Health of Vietnam checks and there's no registration? Problem. What about the validity of arbitration clause? I'm going to go into the details of arbitration very shortly. But is there, first of all, an arbitration clause? Is it valid? What about some other clauses pending other proceedings? I'll give you an example about bankruptcy in Germany. We had a client from Germany that had a licensing agreement with an Italian licensee. The licensee went bust. So the German licensor wanted to find another licensee in Italy to continue the business in Italy. This was against the law. Why? Because both in Germany and in Italy, if a company goes bust, the principle is the contracts remain valid in order for the company's curators to raise some money to pay debts, to pay taxes, to pay employees, to pay outstanding debts, and so on. So terminating the contract on the simple ground of bankruptcy is not valid in a contract like that, in those jurisdictions. However, the solution that we gave was that the Italian party was non-performing. So non-performance generally, at least in civil law jurisdictions, leads to termination, to automatic termination of the contract, termination for legal reasons. And therefore we managed to still terminate the contract, find another licensor, but this is another licensee, sorry, but this is just an interesting anecdote that I'm giving you. Then there are exchanges of emails, as I said before, even voice messages. Recently, courts in all over the world are accepting even WhatsApp, iMessage, Telegram messages as pieces of evidence. Don't count on them too much because they can be forged. There is a whole issue. I work a lot in fintech, in blockchains and digital tokens, and they tend to offer some solutions to this problem, which is that documents can be forged. So why it makes sense to have a written contract? Because it works as a piece of evidence. If you go to court, you have something which has been signed by the parties. If you go to court and you provide the judge with an email, with a text message that maybe was lost, maybe is in an old phone, etc., not. So what about the official language? If you are Vietnamese and you enter into an agreement with an Italian, does the contract have to be in Italian or Vietnamese or English? Sometimes there is no legal provision for that, and we can agree on whatever language we want. So what is the standard structure? I'm following, this is just a very simple structure. You don't need to follow this, okay? It is just a standard structure of a typical contract. The typical contract in private law is the sale and purchase agreement. That is the core of business relations. Pretty much like homicide is the core of criminal law. So standard structure is that of the, in Latin they say nomen juris. What is the nomen juris? Is the definition of the contract. It's the name that you give to a contract. Like I was saying before, you can call a document, a contract, letter of intent, but it's not a letter of intent. So again, I made this very stupid example before of the bottle of water, and I call it mobile phone. What is the name that you give to the agreement? Sale and purchase. But then if the obligation is to rent, then it's a rental agreement. It's not a sale and purchase agreement. So name. Preambles. Vietnamese love preambles. I would say keep it simple. Preambles are interesting where necessary. For instance, if we say that a company is a leader in a certain industry, then the preamble can be relevant, because we expect from a leader in its industry to provide cutting-edge technology, to be on time, to be efficient, essentially. If preambles are legally meaningless, that is, provided that whereas the parties wish to enter this contract in good faith, this is not an interesting preamble. Of course, they want to enter it in good faith, and even if they're in bad faith, they will never admit it. So, write the preambles, include the preambles only where necessary. Then dates. When is the contract entering into force? What about the obligations? This is quite important when there is non-performance. If you clearly define what the parties need to do and what they don't have to do, then it's easier to interpret the contract when there is a problem. So non-performance cases and what happens in case of non-performance. What about limitation of liabilities? What about an interesting example is that many jurisdictions did not consider COVID-19 as an element of force majeure. They said, no, you could work from home. Why are you telling me that COVID-19 is an element of force majeure? So remedies, liquidated damages, what happens if something goes wrong? What about performance bonds and other guarantees? I sell you something at a guarantee that is going to work for 1 year, 2 years, 3 years, etc. What about consideration? Consideration means the payment in exchange for the service, for the sale of the goods. What about governing law and jurisdiction, dispute resolution if there is a problem? And then annexes. Attachments can be very important. I was mentioning before the example of fashion. For instance, in a sale and purchase agreement for a collection of fashion goods, you could have as an attachment the collection itself. So you have an agreement that doesn't clearly state what goods are to be sold or purchased, but you say, okay, we refer to the spring, summer 2021 collection. Okay, you have the annex and you refer to that. And maybe the contract continues over and over. You have spring, summer 2021, autumn, winter 21-22, and so on. So the contract is still there, and the annexes are those that change and make the difference. So governing law and jurisdiction. The key point here is that if the parties have decided on what law and jurisdiction to apply, then usually there is no problem. But what if they have not? As I said before, local laws define what the regulations are, what the rules of interpretation are. The point is, if you do not decide, somebody else will do it for you. I mentioned the Italian law 2018-95. The applicable law and jurisdiction is that with the closest link to the contract. I mentioned it before, the shipment of goods, the construction of a palace, and so on, with a number of notable exceptions. I am a big fan of alternative dispute resolution, especially in international contracts, especially in places like Vietnam. What is alternative dispute resolution? Alternative dispute resolution is the resolution of disputes in an alternative fashion. It is, instead of going to a judge, to a court of justice, you appoint somebody else as a private judge. That private judge is usually an arbitration. There are other forms of ADR, alternative dispute resolution. There could be mediation, which is widely used in Asia, conciliation, assisted negotiation, which is quite trendy in Italy. What is assisted negotiation? It's negotiation conducted by lawyers and trusted by the parties to find an agreement to settle their dispute. Let's focus a little bit on arbitration. There has to be a careful preliminary examination. That is it you cannot go for arbitration in a criminal case, for instance. If there is theft or stuff like that, you cannot go for arbitration. For other things, yes. Is arbitration recognized in your jurisdiction? In Vietnam, yes. Vietnam is a signatory of the New York Convention on the Recognition of Foreign Awards. An award is like a sentence. Is the decision of an arbitral tribunal on a case. So Vietnam, Italy, and many other countries, through the New York Convention, say, okay, we recognize that if there is an arbitration in Switzerland, in Singapore, it is valid in our territory. You can apply it. But what about the costs? Arbitration is notoriously very expensive. What about the qualification of the arbitrators? Do they need to meet certain requirements? Do they need to be specialized in certain fields of law or even business? What about disputes on some technology issues, on software. Do they need to know coding? Do they need to be prepared on technical aspects? One of the reasons why companies go for arbitration is that they think that judges, standard judges in courts, do not have a specific preparation on a certain topic. So they don't understand the topic, and by not understanding the topic, they will not apply the law as they want. So arbitration could be a solution for that. I am coming to the end of my presentation because I wanted to leave a few minutes for questions if there are any. We have 5 minutes left, I see. So I'm more than happy. I'm sorry I didn't do it before. I'm more than happy to share my slides with Dr. Viet Anh and his team, whom I thank a lot. And I'm more than happy to take questions if there are any. Thank you very much.
Thank you very much. Thank you very much. What an excellent shares from Mr. Vasoli. I would like to have our MC take over again to introduce for us the next step. Thảo Nguyên.
Dạ vâng, cảm ơn phần chia sẻ chuyên sâu và giải đáp thắc mắc của anh chị. Anh chị nào có câu hỏi hoặc tình huống thực tế liên quan đến chủ đề ngày hôm nay thì anh chị vui lòng gửi câu hỏi đến cho chương trình. Vâng, xin mời tiến sĩ Nguyễn Việt Anh ạ.
Vâng, thưa các anh chị, trong lúc chúng ta đang chờ đợi mọi người điền form và gửi câu hỏi, chúng tôi xin thông báo có một cái thông báo quan trọng là chúng tôi xin có chuẩn bị một cái chương trình học bổng dành cho các cái đối tượng của sinh viên năm thứ 3 và năm thứ 4, tập trung vào tất cả những cái chuyên ngành quan trọng nhất để trở thành một người gọi là giám đốc vận hành, bao gồm từ quản trị kinh doanh tới kế toán tài chính, quản trị hoạt động. Đây là một chương trình học bổng 100% dành cho các sinh viên tiềm năng cho năm thứ 3 và năm thứ 4. Thế thì rất mong là các anh chị sẽ chuyển cái thông tin này tới những sinh viên mà có tài năng về mặt kinh doanh. Tôi xin cảm ơn. Để nhìn lên màn hình thì đây là cái chi tiết mà chúng tôi muốn, chương trình mà chúng tôi muốn chia sẻ dành cho học bổng 100% dành cho tất cả những sinh viên năm thứ 3, thứ 4 có tài năng về kinh doanh. Tôi xin được gửi các anh chị cái thông tin trên đây và hy vọng các anh chị sẽ gửi đến cho mọi người. Xin cảm ơn các anh chị. Mr. Vasoli, now we have the first question from Mr. Vũ Trường. You have mentioned that the question is, you have mentioned that you may not like the letter of intent. So what tool you suggest to replace this step? Because this is, according to his understanding, this is a very first step that to express the interest in entering the contract. So, you know, the letter of intent, as you said, it may not binding by law, but but it not really, it could be an evidence. So what kind of other things that you suggest?
First of all, let's be clear on the definitions. That is, expression of interest, letter of intent, memorandum of understanding, they tend to be all synonyms. So whatever you call them, they're pretty much the same stuff. So let's be clear on that. Secondly, I would only use one of these instruments if it is necessary. And I cannot tell you in advance if it is necessary or not, but usually it is not. So there is no legal requirement to have a letter of intent. There may be a requirement in practice to have an expression of interest. For instance, in the trading of commodities. In the trading of commodities, usually what you do is you express an interest. Say, I want to buy X tons of coffee beans from Vietnam. Give me your best price and conditions. Okay, you're expressing your interest. But this is because the practice in that industry works that way. But there is no law that says you must express your interest. No. So if it is a standard in that business, okay, you can adopt it. If it is useful for negotiations, then adopt it. If it is well drafted, then adopt it. There's a lot of ifs. Otherwise, just forget about it.
Thank you, Vasoli. And the next question really much relate to that question is from Ms. Quyên, that what is the difference between the binding MOU and the contract?
Essentially none. Perhaps she's referring to the binding aspects of an MOU. So if an MOU is binding, then it is a contract. You can call it MOU, but it's still a contract. As I said before, you can call this mobile phone, but it's water. So there's no difference. But there can be MOUs that are MOUs, intent is the same, that have some binding clauses. So for instance, as I mentioned, there can be confidentiality clauses or standstill clauses. So the letter of intent is not binding. It doesn't force you to enter into the agreement. Stupid example. I want to sell you this bottle of water. We have not decided if I'm selling it to you or not, but we have decided that I cannot sell it to her for the next 2 hours. Okay, that part is binding. If I sell it to her now, within the next 5 minutes, I am breaching an agreement with you. So I can be sanctioned for that, for breach of agreement. But the rest, no. If I don't sell it to you, there's no agreement to that, if I understood correctly.
Thank you. So binding MOU will be the contract. The next question is
Yes.
maybe let me explain to you a little bit. This in Vietnam's culture. In Vietnam's culture, the next question from Mr. Chi Nguyen, that in Vietnam's culture we respect the relationships more than the law, you know. So we have we used to respect the relationships, especially in the southern part of Vietnam. You know, we have the contract over the party, over the drinks, and then the contract, just the things come after. So any advice or any suggestion?
Well, I have to say that Vietnam is somehow the Italy of Asia. So I feel myself very much at ease here. It is very true in many other cultures. And as I mentioned before, one of the fascinating aspects of international legal practice is that you encounter really different cultures and that you learn a lot. Even, I don't speak Vietnamese, but I also understand that in Vietnamese language, personal pronouns are not exactly as we think of them in English or in Italian. You refer to somebody as anh, em, ba, etc., depending on the relationship. So literally, you would translate a sentence as younger man is referring to older woman or something like that. It's always in third person in a way. So it's really fascinating. What is the advice? The advice is, well, don't get too drunk and be healthy. But this is just a healthy piece of advice. The advice is be careful about what you agree when there is no legal requirement for a specific formality. Words, if require you to have a written agreement, be careful about what you agree on over dinner. Say, okay, we agree, shake hands, một hai ba rượu, and that's binding. That's binding. So the piece of advice is be careful. Sometimes relationship can have a positive effect, that when the parties collide, when they fight, maybe they're not as confrontational as in other cultures. In America, it is notorious that people go to court all the time. In Europe, not so much. In Asia, much less, because you value interpersonal relations and you try and solve the matters amicably. So the piece of advice is basically to be reasonable. There is no guiding, there are no laws that apply to this. But sometimes, indeed, personal relations can be very helpful. Naturally, as long as you don't break the law. So the question is, we respect relationships more than the law. Yeah, that's very nice, as long as respecting a relationship is not something that forces you to go against the law. If your friend asks you to commit a crime, you cannot commit a crime. Sorry. That person is still your friend.
Thank you very much. The next question from Mr. Đức Tiến, that he would like to ask about if ADR is used by own company, and about the benefit of ADR. ADR here is stand for Alternative Dispute Resolution. I just want to remind for the audience.
Yes. Yes. No, it is not used by all companies. The benefits are enforceability, in that if you have, it happened to me before. Imagine you have a dispute between an Italian company. There's no arbitration, no ADR. You go to court. Let's assume you go to court in Vietnam. And you win the case against the Italian company. Then you want to enforce the sentence in Italy. Good luck. It will take maybe years to do that. And the other way around is perhaps even more difficult, because the justice system in Italy sometimes is extremely slow. So maybe it takes you 5 years to close the case, to get a positive sentence, a favorable sentence. And then you have to enforce that sentence in Vietnam, which is really a headache. It's a hassle. So the benefit, one benefit of ADR is enforceability and speed. The other one is arbitration centers. That is, a judge doesn't necessarily know in detail a certain business, but you may have certain arbitral centers that are specialized in particular things. You have an arbitration center that is totally specialized on the trading of commodities that I mentioned before. So they truly understand what goes on. They have, so these are essentially the benefits. Speed, freedom, I have not mentioned that. So speed, enforceability, specialization, and freedom to choose where you want to go and what the rules are. Because arbitration, you can set your own rules for arbitration. As long as everybody agrees, you can set your own rules. So that is also an interesting feature of alternative dispute resolution. But no, the answer is that actually most companies do not use ADR. Most companies do not even write in a contract what the governing jurisdiction is. Most companies not even write a contract for that matter. So that is the answer.
Thank you. Thank you. And the next question from Quỳnh, our MBA student, alumni actually. She asking for business contract in Europe. Is it common to use arbitrator or go to the court?
I would say I would use the same answer as before. That is, it is more common to go to court. There are many arbitration centers in Europe. Maybe I would like to pinpoint that certain arbitral centers in Europe are not as expensive as others. For instance, there is the arbitration center in Paris of the International Chamber of Commerce is a private body. Even though it's called international, the name can be deceiving, but it's not, again, a supranational body. It's not the United Nations. It's an association that is called the International Chamber of Commerce, simple as that. And the ICC tends to be quite expensive as an arbitration center. But then there are others like the European Court of Arbitration, which has nothing to do with the European Union. So again, the name European Court may be deceiving. That's also a private entity, and that's relatively cheap. So it's normally bigger cases, though, that go for arbitration. This is because traditional arbitration used to be, at least in the past, very expensive. So it would not be worth going for arbitration for a smaller case. Now, as I said, it's becoming cheaper and cheaper.
Thank you. There's a question from Chu, Miss Chu, sending directly to me that she's asking about, have you follow up the case of one-side contract on internet of Twitter and former President Donald Trump, that Twitter has disconnected his account. So she's asking about is that Twitter doing the right thing, or just they can do whatever they want without any law enforcement?
I have not read the terms and conditions of Twitter, so I don't know if what they're doing is right in terms of law. So I'm not here to say whether it's right or wrong morally. We're talking about the law. So if they suspended former President Trump's account on grounds of breaking the terms and conditions, then they were right in doing so. Because theoretically, when you join Twitter, you should read the terms and conditions and you say, okay, I will behave according to the terms and conditions. Then, of course, there are two moral aspects here to consider. One is the role of these tech giants. That is, they're private companies. And in theory, you can disagree with them. You want to tweet whatever you want? Well, fine, I'll kick you out. It's a private thing. but their role in society is huge. So yes, they're private. Yes, they set their own rules, and it is fine that they set their own rules. But the impact that these companies, Twitter, Facebook, etc., have on all of us is immense. So perhaps the question here is, should they be regulated differently? And probably the answer is yes, because otherwise they have too much power in private hands, and this can be dangerous. So this is quite important, but it's something that has nothing to do with the case itself. It is a possible solution for a problem that is there. We'll know that is there, but nobody has addressed. So the quick answer is probably they were right if President Trump was in breach of the terms and conditions. Then there is another moral aspect that I was forgetting about, which is that of the length of terms and conditions. Somebody made a study a few years ago that if you were to read, if the average person in America were to read all the terms and conditions of the average number of things that you subscribe to. So in America, almost everybody has a Facebook account, a Twitter account, an Google account, a Netflix account, and so on. It would take, I don't know how many years for people to read these terms and conditions without including the amendments to these terms and conditions. So again, there is a moral issue here. Can you realistically expect that people read these things and understand them? No. So this is where the European Union is a bit more advanced, because it gives rules like the GDPR on data protection that are enforceable in protect consumers, they read or not, and regardless of what private companies write.
Thank you. And the same question from the same person of Ms. Chu is she's asking about the force majeure during the COVID-19. A lot of customer, from European countries has cancelled the contract, especially in the agricultural products. For example, prawn and fish, they have to cancel the contract. So you think that really a force majeure at the moment? You can use that at the moment?
I'll give you a typical lawyer's answer. It depends. It depends on the industry. It depends on the circumstances. Now, and it depends on the country, because you mentioned Europe, but the European Union is a strange animal. You have harmonized rules, but then every country enacts its own laws. So what is force majeure in Germany may not be force majeure in Romania. So, or the other way around. So the elements are, what country we're talking about, what industry, and what circumstances. And then we have to see what the law says in every country. Italian law, for instance, is quite broad in defining force majeure. That is, it doesn't define it that well. It says when there is an impossibility to perform the contract obligations. Now, is COVID-19 an event that can prevent the parties from performing their contractual obligations? Not all the time. If you work in the hotel industry or in the aviation industry, yes, of course it is, because there are restrictions imposed by governments. You open your hotel, you fly your aircraft. So yes, it is an element of force majeure because there has been an order from the government to shut down. If you're a lawyer, you can work from home. I cannot say, there's COVID-19, so you know what, I'm not sending you the letter that you asked me for and that you paid for. No, I can write the letter from anywhere in the world, including from my home, if I have a good internet connection. Am I supposed to have an internet connection at home? Maybe by choice, I only have an internet connection at the office and not at home. But in 2020, 2021, perhaps it is reasonable to think that everybody has an internet connection at home. What about contingency plans? There are these theories that COVID-19 was a conspiracy, but regardless of this, somehow it was expected that a pandemic or at least an epidemic would hit. So are companies really so unprepared? This goes a bit beyond, but I'll give you an example. In Italy, the government gave funds, like many other governments in the world, to industries that were heavily affected by the virus, for instance, the restaurant industry. Then they checked their balance sheets and their tax returns for 2019 and 2018. And they said, okay, we're going to give you, I don't know, 5% of your turnover in 2019. Oops, their turnover in 2019 was super small because restaurants, of course, accept cash and they forget to declare it. So their turnover is really small and they pay very little taxes. And therefore, the funds that they get from the government is really small. And now they complain that they cannot survive because of the pandemic, because they didn't receive enough money from the government. Probably it was because they didn't pay enough taxes the previous years. But anyway, this goes beyond the point.
Thank you. That depends on circumstance. Yes, we can argue on that. Next, you have the MC just sent me the information of one of the youngest audience today, Mr. Đức Tiến, last year from the law school, Hanoi Law School, I guess. And Mr. Đức Tiến, do you want to say something, or you want me to read your question? The question from Mr. Tiến is, I am wondering if arbitration has the appeal level similar to the court procedures.
The quick answer is no. The long answer is depends. Depends on what you agree. That is, usually arbitration centers do not provide for an appeal procedure, but the parties can agree on that. And there is also a further complication, which is that usually, no, not usually, but sometimes the parties may challenge the validity of the arbitration itself. So what they do is they fight. They will need to go to arbitration. One party says, okay, I'm invoking the arbitration clause. I'll take you to the arbitration court. And the other says, wait, the arbitration clause is not valid, or at least it is not valid for this specific case. Let's ask a judge if the arbitration clause is valid. So everything is frozen. It stays there until the judge says, yes, you can go for arbitration, or no, you cannot. And maybe the judge says after 2 or 3 years, yes, you can go for arbitration. Then you go for arbitration and you continue the case. But in the meantime, so many things have happened. But the quick answer is generally no.
Thank you very much. Please, audience, because we are kind of quite many questions. Anybody want to speak directly to the speaker, to Mr. Vasoli? Quỳnh, you have a question. Do you want to say something? Quỳnh has a question that I want to know if there is a class you teach more about null and void, in online class.
No, unfortunately, I don't think there is a class where I will teach more about this, but I'm more than happy to discuss it with you. And of course, I'm more than honored and happy to give other lectures in the future to Andrews and the National Economic University. More than happy.
Thank you, because this is a very difficult things in contract when I study law. So, and also Vietnamese law is so different. That's why I'm asking you here in this class. I would like to know more about this. It's a term that in Vietnam we separated it as one part is null and void, and some contract is the whole contract is null and void. Kind of like very complex. So if you have any online class, I would like to join then.
I will let you know, but the quick answer is that if the clause is not essential to the contract, then you can render the clause null and void, but keep the contract going. For instance, you agree that the contract will be in English, but the law says that the contract must be in Vietnamese. Okay, fine, that clause is not valid and the contract will be in Vietnamese. Fair enough. It's not really essential, even though, of course, language matters and the law is a science that works with words. But again, the main obligation is not about language. If the main obligation of the parties the clause that regulates the main obligation of the parties is rendered null and void, then the whole contract falls. That's the simplest way to try and answer your question.
And Đức Tiến wants to continue his previous question. Hold on, let me extract that question out. He continued the question, previous question about arbitration has the appeal level similar to the court procedure. That means the decision of the arbitrator is the final verdict. And if they, you got that, if they somehow wrong, how could the losing party protect their rights and benefits?
Okay, if there is no provision for appeal in the clause or in the arbitral center that was chosen, then yes, it is a final verdict. Let me explain. The clause could say, we choose the, I don't know, Singapore International Arbitration Center to settle our dispute, according to their rules. Now, if the rules of the Singapore International Arbitration Center provide for appeal, then okay, yes, of course you can appeal. If they don't provide for appeal, then it's final. Then the clause can also say, the decision of the Singapore International Court of Arbitration, whatever, can be appealed at these conditions. And then you set the conditions. Or you can say it can be appealed at this other body. So two important points. One, the parties should agree beforehand that there can be an appeal. And secondly, the arbitration center that they choose or the rules that they themselves set should provide for appeal. This is very important. Usually, the reason why there is no arbitration because it's fast. If there is appeal, it's not fast anymore, so you waste time. Now, if there is a violation of law, you can go against the arbitration award in court. So you go to court and you say, look, the arbitration center took this decision, but this decision is against the law, so it cannot be enforced. But you cannot ask the court to judge on the facts. It has to be on point of law, not a point in case. A case in point.
Thank you. There may be the time slot for the last question. And the last question from Chu is quite large. Maybe outside the scope of the seminar today, but I still want to read it in case you can have some advice. And he's asking about the kind of best practice for the negotiating the international contracts. It could be answer later, but if you got any suggest at the moment,
yes,
that would be the last question.
Yes, it's a broad question, but I would suggest it's very nice. I would suggest protecting your rights and interests from the. So businesses tend to be very enthusiastic to say, yes, we're going to sell a lot of products to Vietnam. Yes, we're going to do this business, etc. And there has to be this sparkle. There has to be this enthusiasm. Without this enthusiasm, there's no business. So go for it, but do protect yourself. So the broad answer that I would give is protect yourself as early as possible. For instance, register your trademarks in advance, because it takes a long time. It takes maybe 18 months, 24 months to have a trademark registered. Sign an NDA. A mutual NDA is fine. Do not accept a unilateral NDA from the other party that says you cannot disclose my information. What about your information? So sign an NDA, collect evidence, and put everything in writing, and try and have one single document as the agreement if and when it is signed. That is the broad thing that I would say. And also learn about the other party's culture and context, which I mentioned before. That is, I'll give you a fun example. I had a case many years ago in Mongolia, and there was a problem because there was a construction company from Italy that went to Mongolia. They wanted to build a number of constructions in Mongolia, but then they realized that the temperature is freezing in Mongolia from October, November until April. And it is impossible for workers to stay outside. Maybe it's minus 20, minus 40 degrees. It's freezing outside. So, and of course they had to delay the project until the next summer. So it's a very stupid example, but do take these things into account, because certain factual aspects can have a big impact on the contract.
Thank you very much, Mr. Vasoli, and that is the last questions. We would like to turn to our MC.